When it comes to administering an estate after a loved one has died, real estate can be a little bit confusing. We end up with a lot of questions about, does the property have to go through probate? What do I do if I need to sell the property? Who's supposed to pay the mortgage and the expenses for the property? So today I'm going to talk about what happens to real estate when it's part of an estate. Now, the first thing to know is that most of the time, real estate is actually not a probate asset, and this usually surprises people. But unless the will gives specific instructions for the executor to sell the property and distribute the proceeds, then usually the real estate's not going to be part of the probate, and it vests automatically in the heirs. Now, while this can sound like a good thing, it can create a few problems. The first issue we run into is because the property vests in the heirs right away, that means that they suddenly become responsible for all of the expenses of that property, the mortgage, the property taxes, utilities, and insurance. And usually at this point, they haven't received any monetary assets from the estate yet, so it can create a real financial hardship for them. Now, if you're in this situation, it might be tempting to say, well, I'll just use the estate checking account to pay the bills for the time being. But in the long run, that can actually make more work for yourself because it's going to be really hard to reconcile those accountings with the court later on. The other issue we run into frequently is that there's usually multiple heirs, and some of them might be in a position to help with the financial obligations of the property, but not all of them. So then how do we reconcile that going forward? If you're in that situation, it's going to be really important to have a written family agreement about who's handling those expenses and how they're going to get reimbursed. Otherwise, we've seen people get burned at the closing. The real estate attorney can only divide the closing proceeds based on the percentages that each heir is supposed to receive, and they can't make any adjustments because there was some sort of oral agreement about who is paying those expenses. So if you find yourself in this situation, it's definitely worthwhile to talk to an estate's attorney and make sure that you're handling things correctly. Now, as if this isn't already confusing, even though the real estate is not a probate asset, it can still be subject to creditor claims. So especially if the estate is insolvent, the executor may be obligated to pull that real estate back into the estate so that they can sell it to pay any debts or claims against the estate. Now, once they do that, any remaining funds will still get distributed back to the heirs, but it's a little gotcha that you need to be aware of. And lastly, let's talk about selling the real estate, because that's often what happens in these situations, and it can be a little bit confusing. Even though that property may not be a probate asset, it's still subject to any creditors or debts or claims against the estate for 2 years, which means if you need to sell that property, then an estate filing may be needed before we can proceed with selling it. And one of the things that we're going to need to do is publish what's called a notice to creditors in the newspaper. Now, the right type of filing is going to depend on the total composition of the estate. But once we get that estate opened, that can take a few weeks. And then the notice to creditors period has to run for 90 days before we're going to have clear title to sell that property. So if you're thinking about meeting with a listing agent, you might want to meet with an estate's attorney first to make sure you know what the process is going to look like, whose name should be on that listing agreement, and how quickly you're going to be able to close on the property. So if you found some of the information in this video to be confusing or overwhelming, you're not alone. Our estates team helps families in these circumstances all the time. So give our office a call. We'll send you a free copy of our guide to understanding estate administration, and we'll help you figure out your best next steps.